dear learners, welcome to this session. Today we will be discussing the United Nations Convention against Transnational Organized Crime and Human Trafficking in India. So we have this convention and still we find people across the globe being trafficked. So we will discuss human trafficking in view of this convention. General Assembly Resolution 55/25 of 15th November 2000 gave this convention. The General Assembly, recalling its Resolution 53/111 of 9th December 1998, in which it decided to establish an open-ended intergovernmental ad hoc committee for the purpose of elaborating a comprehensive international convention against transnational organized crime and of discussing the elaboration as appropriate of international instruments addressing trafficking in women and children, combating the illicit manufacturing of and trafficking in firearms, their parts and components and ammunitions, the illegal trafficking in and transportation of migrants, including by sea, strongly convinced that the United Nations Convention against Transnational Organized Crime will constitute an effective tool and the necessary legal framework for international cooperation in combating inter alia such criminal activities as money laundering, corruption, illicit trafficking in endangered species of wild flora and fauna, offences against cultural heritage, and the growing links between transnational organized crime and terrorist crimes. So, we will be discussing this convention only related to human trafficking. So, adopts the United Nations Convention against Transnational Organized Crime and the Protocol to prevent, suppress and punish trafficking in persons, especially women and children, supplementing the United Nations Convention against Transnational Organized Crime and the Protocol against 2A/AC 254/34, the smuggling of migrants by land, sea and air, supplementing the United Nations Convention against Transnational Organized Crime annexed to the present resolution and opens them for signature at the high-level political signing conference to be held in Palermo, Italy from 12 to 15 December 2000 in accordance with the resolution 54/129. This is the reason why this has also been called, a very important convention as it caters to all the three aspects. Article 1 of this convention talks about the purpose. The purpose of this convention is to promote cooperation to prevent and combat transnational organized crime more effectively. Article 2 defines different terms, and here we are only discussing terms which are related to human trafficking. For the purposes of this convention, an organized criminal group shall mean a structured group of 3 or more persons existing for a period of time and acting in concert with the aim of committing one or more serious crimes or offences established in accordance with this convention in order to obtain directly or indirectly a financial or other material benefit, a very important purpose. Serious crime means, shall mean conduct constituting an offense punishable by a maximum deprivation of liberty of at least 4 years or more, serious penalty. Structured group, which has been defined in C, shall mean a group that is not randomly formed for the immediate commission of an offense and that does not need to have formally defined roles of its members, continuity of its membership, or a developed structure. So, in cases of trafficking groups, these are all structured group. Proceeds of crime shall mean any property derived from or obtained directly or indirectly through the commission of an offence. Freezing or seizure shall mean temporarily prohibiting the transfer, conversion, disposition or movement of property, or temporarily assuming custody or control of property on the basis of an order issued by a court or other competent authority. Confiscation, which includes forfeiture, where applicable, shall mean the permanent deprivation of property by order of a court or other competent authorities. This is very much needed in cases of places used for trafficking. Article 3 talks about scope of application of this. This convention shall apply except or otherwise stated herein to the prevention, investigation and prosecution of the offence established in accordance with Article 5, 6, 8 and 23 of this convention, and serious crime as defined in Article 2 of this convention, where the offence is transnational in nature and involves an organized criminal group. So, human trafficking can be a serious concern and is a serious offence and will be taken into consideration under this article. For the purpose of paragraph 1 of this article, an offence is transnational in nature if it is committed by more than one state. In case of human trafficking, we know that it is committed in more than one state. Globally, we have human trafficking cases. It is committed in one state, but a substantial part of its preparation, planning, direction or control takes place in another state. We have destination areas, we have transit areas, we have source areas. So, this is also applicable on us. It is committed in one state but involves an organized criminal group that engages in criminal activities in more than one state, or it is committed in one state but has substantial effect in another state. Article 4 talks about protection of sovereignty. State parties shall carry out their obligations under this convention in a manner consistent with the principle of sovereign equality and territorial integrity of states and that of non-intervention in the domestic affairs of the states. Nothing in this convention entitles a state party to undertake in the territory of another state the exercise of jurisdiction and performance of functions that are reserved exclusively for the authorities of that other state by its domestic laws. Article 5 talks about criminalization of participation in an organized criminal group. Article 6 talks about criminalization of the laundering of proceeds of crime. Article 11 says prosecution, adjudication and sanctions. Each state party shall make the commission of an offence established in accordance with Article 5, 6, 8 and 23 of this convention liable to sanctions that take into account the gravity of that offence. Each state party shall endeavour to ensure that any discretionary legal power under its domestic law relating to the prosecution of persons for offences covered by this convention are exercised to maximize the effectiveness of law enforcement measures in respect of those offences and with due regard to the need to deter the commission of such offences. In the case of offences established in accordance with Article 5, 6, 8 and 23 of this convention, each state party shall take appropriate measures in accordance with its domestic law and with due regard to the rights of the defence to seek to ensure that conditions imposed in connection with decisions on release, pending trial or appeal take into consideration the need to ensure the presence of the defendant at subsequent criminal proceeding. Each state party shall ensure that its court or other competent authorities bear in mind the grave nature of the offences covered by this convention when considering the eventualities of early release or parole of persons convicted of such offences. Each state party shall, where appropriate, establish under this domestic law a long statute of limitations period, and we have Limitation Act, in which to commence proceedings for any offence covered by this convention, and a longer period where the alleged offender has evaded the administration of justice. A very important article. Nothing contained in this convention shall affect the principle that the description of the offences established in accordance with the convention and of the application, legal defences or other legal principles controlling the lawfulness of conduct is reserved to the domestic law of a state party, and that such offences shall be prosecuted and punished in accordance with the law. Article 16 talks about extradition. You know, if you have committed crime in a foreign land, then you can be extradited from one place to another. So, we will ask you, you just commit a crime in India and you run away. So, the government can ask for extradition. They will ask the other government to send you back to the country of where you committed crime. So, we have extradition cases also. Then Article 17 talks about transfer of sentenced persons. Article 18 talks about mutual legal assistance. 19 talks about joint investigation. Article 20 talks about special investigative techniques. So, special investigative techniques, you know, if clubbed with modern technology, can be very fruitful in addressing the issues of human trafficking. Article 22 talks about establishment of criminal record. It is very important to maintain the record of habitual criminal for people who are involved in trafficking for long years, either convicted or not convicted, because that will help in further convictions. Article 24 and 25 deals with protection of witnesses. The witnesses in human trafficking cases need to be protected. So, this article is very much relevant for people who become witness in cases of human trafficking. Article 26 deals with measures to enhance cooperation of law enforcement authorities. This is also very important, when you have to have a measure to enhance cooperation. Across the globe, we have this problem of human trafficking. So, how do states come together and address this issue in a collective way, so that at the transit, at the destination and at the source, the issues of human trafficking are handled properly in a multidimensional approach in cooperation with all the state governments. Article 28 deals with collection, exchange and analysis of information on the nature of organized crime. A very important article, So, so much data can be collected in one state and can be shared with the other state. It can be analyzed. So, we can track who are the countries which work as source or which work as transit. What are the destination countries? What are the linkages between these countries? What are the laws in these countries to handle the issues of human trafficking? What are the implementation lacunas? And then we can address as a team to, to address the issues of human trafficking and to curb this crime. Article 29 deals with training and technical assistance. Training is very important, technical assistance is very important to address the issues of human trafficking. All the stakeholders have to come across, have to come together with proper training, with technological know-how, and address the issues of human trafficking globally. Article 30 deals with other measures. Implementation of the convention through economic development and technical assistance. We had just discussed that if you target the economic development of the country or technical assistance, then you will not have human trafficking cases. So, Article 30 is very much relevant for human trafficking cases. Article 31 talks about prevention. Prevention is better than cure. So, when you can prevent something, it will be that you are protecting somebody's dignity and worth and a crime to happen. Article 34 deals with the implementation of the convention. Article 35 talks about settlement of dispute. If there is any dispute, how will that dispute be resolved by the competent authorities? Article 39 deals with amendment and Article 40 deals with denunciation. So, you can amend this convention, and how can the amendment take place in the convention has been dealt under Article 39. Article 40 talks about denunciation. Now you have been a party to this convention, and later on you want to denounce. You want to just say that no, I am no more a party to this convention. Then what are the procedures? What needs to be followed at the country level to give away the membership of that convention is mentioned under Article 40. In the end, I would just like to say that it is very important to address the issues of human trafficking globally, because human trafficking is a crime against humanity. It is not that we are we have technological interventions to address the issues globally. We have different laws catering to human trafficking globally. Then we have different stakeholders under different capacities working to address the issue of human trafficking. So, all the state parties to this convention should come together and have the laws implemented properly in their local sphere. The demand factor and the supply factor globally should be addressed by the state parties, and they should come up together to address the issue of cutting down the demand for human trafficking and even the supply side by properly implementing the public distribution system, by having a law on human trafficking, by implementing the law strictly on human trafficking, by having provisions wherein you provide quality education to people so that they are not trafficked, by removing the vulnerability of the person. If a person is vulnerable, then he can be trafficked, because the trafficker will take that person for his advantage, for his earning money, for any kind of commercial purposes. So, as human beings cannot be sold and purchased, so if we have proper coordination between the United Nations agencies and between the states, and they all come together with a proper law, then the law is implemented in that country. Across countries also, if we have a proper plan of action, that suppose India is a source country, then how we will be tackling the issues of source, or India is a destination country, then how we will be addressing the issues in India. Similarly, if people go without valid visa and passport to another country, then what will be the status of implementation of law? Whether the people will get rescued at the country where they have run away without valid papers, whether the government will take action against people who have come without papers or without proper documents, or they will be deported back to the country, whether The people can contact the administration even if they are new to a country without valid documents. Do we have the embassy of the country from where they have come? And they can just go and contact the embassy and seek help and advice. Do we have proper plans so that the family members sitting in India can make a complaint to the Ministry of External Affairs, and Ministry of External Affairs act as a agent in the other country where the person has gone for work without valid visa and passport, and sometimes is also missing now. The parents do not know where the person is, where the daughter or the son is. So, to know the whereabouts of the child or the adult, the government of India will come to rescue and will help these people. People who go for marriage in different countries, the parents are unaware about the status of the girls. The parents are not even able to know whether the girls are safe now. Many a times in cases of human trafficking, the marriages happen and then people sell these girls. So these issues can be addressed if we follow this convention properly. Then we have a proactive convention on the migration issue also. So migration and missing people can be linked to human trafficking. So how can we link the issue of migration and the issue of missing with human trafficking? Now, as you all have heard and seen that even the convention talks about reporting of missing people, having a proper record of people who are involved in habitual crimes. So if we have records of these people, then they can be targeted, they can be penalized, they can be convicted by the court of law. If there is a mechanism to protect the witness and to protect the witnesses, victims and witnesses, as there in the convention, it will be a pro-benefit legislation for the person who has been trafficked, because normally in want of proper safety, a person does not want to become a witness. So if we have a mechanism where a person can come and speak up, then we will be able to address the issue of human trafficking at the global level, and we will be able to see that people in India and across the globe are not trafficked. Thank you for this session. Stay blessed and stay happy.